Hi and a very good morning. My name is Tinash, and our purpose of this video presentation is to explain the 5 situations given by the Project 2 questions. So now for situation 1, the Cepat Sehat Sendirian Berat, a Malaysian pharmaceutical company, launched a nationwide advertisement for its latest product, the Immuni Patch, claiming it could prevent serious skin allergies and infection caused by environmental pollutants. The advertisement stated that RM10,000 will be paid to anyone who uses the Immuni Patch daily for 30 days as directed and still develops a severe skin allergy. To prove our sincerity, RM100,000 has been deposited with June Bank. Encouraged by the advertisement, Ida, a nurse with sensitive skin, bought the Immuni Patch and followed all the instructions. Despite this, she developed a serious allergic rash after 3 weeks. When she demanded the RM10,000 reward, the company refused, claiming that the advertisement was merely a promotional gimmick and has no intention to pay anyone. There are 3 issues in this case: whether the advertisement by Cepat Sehat Sendirian Berhad constitutes a binding unilateral offer or is merely an invitation to treat. And the second one is whether the deposit of RM100,000 in June Bank manifests a legal intention to be bound by terms of the advertisement, and whether Ida's conduct of purchasing and using the Immuni Patch as directed constitutes a valid acceptance of the offer. Okay, now let us look at the relevant law application which relates to this case. Under Section 2, Subsection A of the Contracts Act 1950, when one person signifies to another his willingness to do or abstain from doing anything with a view to obtain the assent, he is said to make a proposal. So in this case, there's clearly an offer made by the offeror, which is Cepat Sehat Sendirian Berhad. So Section 2A of the Contracts Act 1950 definitely applies. And under Section 8 of the Contracts Act 1950, the performance of the condition of a proposal constitutes an acceptance of that proposal. So clearly Ida has done an acceptance by conduct. There is a valid acceptance by Ida, and a unilateral contract applies to this case. An offer can be made to the world at large. Unilateral contract is when where a promise is made in exchange for the performance of an act. The offeror's obligation remains outstanding until the offeree performs the condition. So yeah, there are 3 main relevant law application for this case. First is Section 2, Subsection A of the Contracts Act 1950 and Section 8 of the Contracts Act 1950. And we have to understand what is unilateral contracts. So there are some cases that we can review which relates to this case. First, we have to know the distinction between a binding offer and a mere invitation to make an offer, which is fundamental concept in contract law. So in Khalil and Kabalik Smokeball Corporation, it establishes that while most advertisements are invitation to treat, an advertisement offering a reward for the performance of an act can be a binding unilateral offer to the world at large. And in the case of Partridge and Crittenden, it illustrates that the general rule of advertisements are normally regarded as an invitation to trade, not an offer for sale. And last but not least, the Preston Coppin, Sendirian Berhad and Edward Leong. In this case, the Barrel Court of Malaysia held that an offer is an intimation of willingness to enter a contract. In this case, quotations were held to be mere supply of information and not a binding offer. Now let's get into the application part. First, let's know if there is an intention to be bound by Cepat Sehat Sendirian Berhad. Cepat Sehat's claim that the ad was promotional gimmick is likely to fail, similar to the Khalil's case. Crucially, the deposit of RM100,000 in June Bank to prove sincerity provides objective evidence that the company intended to be legally bound by its promise. And let's know what is the unilateral offer to the world. The advertisement was a unilateral offer made to the public. It invited any person to accept by performing the act of using Immuni Patch according to the instructions. So there was a clear unilateral offer done by the Cepat Sehat Sendirian Berhad company. So in Ida's case, is there a valid acceptance? Yes, there is a valid acceptance by conduct. Ida, as a nurse with sensitive skin, saw the advertisement and acted upon it by purchasing the product and following the instruction. This conduct constitutes a valid acceptance under Section 8. No prior notification to the company was required. So, in conclusion, Cepat Sehat Sendirian Berat advertisement constitutes a legally binding unilateral contract. Aida fulfilled all the conditions of the offer and suffered the exact harm contemplated by the advertisement. The company's refusal to pay is contrary to established principles of contract law. Accordingly, Aida is legally entitled to the RM 10,000 reward, and Cepat Sehat Sendirian Berat would likely be held liable by Malaysian court. Thank you.
Situation 2. Meanwhile, Aida's father, Rahman, had entered into an agreement with his close friend Johan. Both men agreed that if their children, Aida and Johan's son, Hafiz, married each other, each father would give 50,000 ringgit to the couple as a wedding gift. When the marriage took place, Rahman fulfilled his promise, but Johan died before making the payment. Hafiz and Aida tried to claim the 50,000 ringgit from Johan's estate, but Johan's executor refused, arguing that they were not parties to the contract. There are two issues that can be found here. Is that number one, whether Aida and Hafiz, as third party beneficiaries, have the legal standing to enforce the agreement made between Rahman and Johan against Johan's estate. And number two, whether the doctrine of privity contract prevents the couple from claiming the 50,000 ringgit wedding gift from the executor. Case laws. The first case law is Tweedle and Atkinson, 1861, a foundational case involving an agreement between two fathers to pay a groom a sum of money upon marriage. The court held the groom could not sue the estate because he was a stranger to the contract and provided no consideration. Second case is Capone Prospective Ltd and Schmidt, confirmed that Malaysian law follows the English doctrine of privity and does not recognize jus quaesitum tertio, the right of a third party to enforce a contract. Third case is Dunlop Pneumatic Tire Co. Ltd and Selfridge and Co. Ltd, established that only a party to a contract can sue on it, and that consideration must move from the promisee to the promisor. Fourth case is Baswick and Baswick, held that a third party beneficiary, a widow, had no standing to sue in her personal capacity for a benefit promised in a contract to which she was not a party. Lim Foo Yong and Sons, Reality Sedian Berhad and Dato Eric Taylor. The Supreme Court ruled that only a party to the contract or their estate can sue for loss or damage. A person cannot claim for losses in their personal capacity if they were not a party. Right, application. The scenario is identical to the case of Tweedle and Atkinson. Rahman and Johan made the agreement, and Aida and Hafiz are the children/beneficiaries. Just as the groom in Tweedle could not sue the father's estate, therefore, Aida and Hafiz cannot sue Johan's estate because they are not parties to the contract. Secondly, relation of Kepong Prospective Ltd and Schmidt. To this case is we can see that although the 50,000 ringgit was clearly intended for Aida and Hafiz's benefit, Malaysian law follows the common law rule that third party rights are not recognized. Therefore, the intention to benefit them does not grant them a legal right to sue. Other than that, by applying Dunlop Pneumatic Tire, we fairly say that Aida and Hafiz provided no consideration for Johan's promise. The reciprocal promises and the 50,000 ringgit payment were exchanged only between the two fathers. Because consideration did not move from the couple, they cannot enforce the promise. Lastly, Beswick and Lee Foo Yong, Aida and Hafiz are attempting to claim the money in their personal capacity. These cases establish that such a claim is invalid because the couple remains strangers to the original agreement. Only Rahman, as the other party, or Johan's estate could theoretically be involved in contractual litigation. Okay, so the conclusion of this case is that the executor's refusal is valid. Under the doctrine of privity, Aida and Hafiz are not parties to the contract and therefore lack the local standi to enforce it against the estate. Final outcome is that the couple is legally barred from claiming the 50,000 ringgit. Only Rahman, as the surviving party who provided the original consideration, would have the standing to potentially sue for a breach of the agreement.
So the third situation will be the financial arrangement between Ida and her mother. So as we see in this situation, Ida was facing financial difficulties and accepted her mother's offer to leave her nursing job and pursue a law degree full-time. Then her mother promised to provide her a monthly allowance of 2,000 ringgit until she graduates. However, after 1 year, disagreements arose between them and the mother stopped providing the allowance, stating that family arrangements are not contract. So as we can see from the facts, Ida was facing financial difficulties while working as a nurse, and then her mother offered to support her financially if Ida left her job and studied law full time. And the next, the mother promised to pay Ida a monthly allowance of 2,000 ringgit until she graduated, and Ida relied on the promise and gave up her nursing job to pursue her law studies. After 1 year, disagreement arose between Ida and her mother. The mother stopped paying the allowance, stating that family arrangements are not legally binding contracts. So this is the facts. So next, we'll be looking at the legal issue, which is the main issue will be in this situation, whether there was an intention to create legal relations between Ida and her mother. So next, the intention to create legal relations. So we'll be looking at what are the cases that applied. So under contract law, for an agreement to be legally binding, there must be an intention to create legal relations. Generally, agreements made within a family or domestic context are presumed not to be legally binding. So the principle was clearly established in the case of Balfour versus Balfour and later applied in Johns and Patwardhan 1969. So in Johns and Patwardhan, a mother promised to financially support her daughter while she studied law. The court held that the arrangements was merely a family agreement and lacked legal relations. So followed by this is the application to Ida's case. Similarly, in Ida's case, the promise was made within a family relationship between a mother and her daughter. The financial support was offered out of parental support rather than legal obligation. So there was no evidence of formal documentation, commercial motivation, or clear intention that the arrangement would be legally enforceable. Therefore, the circumstances strongly suggested that this was a domestic arrangement rather than a contractual agreement. In conclusion, applying the principle from Johns and Patwardhan, the arrangement between Ida and her mother lacks intention to create legal relations. As such, the mother's decision to stop providing the monthly allowance does not amount to a breach of contract. The agreement is not legally binding. Followed by, there was another issue, which is the issue is whether Ida provided a valid consideration for her mother's promise of a monthly allowance. Next, we will be looking at the relevant law that could be applied in this case is under Section 2D of the Contracts Act 1950. Considerations is defined as something done or promised to be done at the request of the promisor in return for a promise. Next, the cases involved is the Curry and Nisa, 1875. The court held that the consideration may consist of either a benefit of the promiser or detriment suffered by the promisee and is often described as the price paid for a promise. So in this case, Ida gave up her nursing job and pursued full-time legal studies at her mother's request. So by leaving her employment, Ida suffered a clear financial detriment as she forfeited a stable source of income. Although the mother did not receive a direct financial benefit, the law recognized that detriment to the promise alone is sufficient to constitute consideration. Therefore, Ida's decision to leave her job and rely on the promise allowance satisfies the requirement of consideration. So as a whole, in conclusion, Ida's actions amount to valid consideration under Section 2D of the Contracts Act 1950 and the principle established in the Curry and Nisa. Accordingly, the element of consideration is satisfied in this arrangement.
So next we move to the Ida's government scholarship bond. So this case involved a government scholarship where Aida was required to serve under a bond after completing her studies. So the issue arose when she resigned before completing the full service period, which led to the dispute between Aida and the government. So for this slide, we look at the dialogue between Aida and the government. So the government demand that Aida have to repay the entire bond amount after she resigned. So, however, Aida argued that the terms were unfair and that requiring full repayment amounted to a penalty. So this dialogue shows that the conflict between them were enforcing the bond strictly, and Aida's claim that the term that are unreasonable. So as you can see, there are three important facts in this case. So first one is the Aida joined the Ministry of Health under 5-year government scholarship bond. And then the second one is she resigned after only 2 years in order to work overseas. And the last one is the government demand full repayment of the bond, while Aida argued that the terms were unfair and constitute penalty. So the issue in this case is whether Aida must repay the full scholarship bond and whether the terms amount to an unfair penalty. In other words, even though Aida breached the bond by resigning early, the question is whether the government is legally entitled to claim the entire bond amount or whether the law allows the amount to be reduced. Next, Section 75 of the Contract Act 1950 will apply to this case. So this section states that when a contract specifies a sum for breach, the party is only entitled to reasonable compensation, not the full amount automatically. So in Salva Kumar Anak Lelaki Merugia against Tiagaraja 1995 1 MLJ at 17, the court held that the sum must reflect actual or reasonable loss and cannot be punitive. This is relevant to Aida's case because although she resigned 2 years of her 5 years scholarship bond, the government is not automatically entitled to full repayment. So the court can reduce the amount to reflect the partial service she completed, to ensuring the fair compensation. Okay, so this issue falls under Section 75 of Contract Act 1950, which deals with the compensation for breach of contract. So under this section, which is Section 75, when a contract states a sum payable upon breach, the party is only entitled to reasonable compensation and not automatically the full amount. So in Aida's case, although she breached the bond, she had already served 2 years. So therefore, demanding the full repayment may be unreasonable, and the court may reduce the amount payable to reflect reasonable compensation. So in simple terms, the contract is valid, and the government cannot demand full amount from Aida. So in conclusion, Aida did breach the scholarship bond by resigning early. However, under Section 75, the government is not automatically entitled to full repayment. Instead, the court is likely to award only reasonable compensation, taking into account the 2 years Aida had already served.
Now, let's take a look at Situation 5, which states Aida's decision to buy a house from Laila, a property agent in Seremban. The conversation between Aida and Laila started when Aida made an inquiry to Laila to buy the house from her. Laila later offered to sell the house for Rm500,000, but Aida made a counter offer to the original price by requesting the house for Rm450,000. However, Laila later refused to sell the house for Rm450,000. Then, when Aida changed her mind, she requested again to Laila to sell the house for Rm500,000 again. But now, Laila informed Aida that the offer has been closed. These are the facts of the case where Aida proposed to buy Laila's house located in Seremban and would offer to sell the house for RM500,000. Aida then replied to buy the house for RM450,000, which stipulated to counter offer where Laila rejects it. Aida later changed her mind to buy the house for RM500,000, but unfortunately now Laila replied that the offer has been ended. The first issue in this case is whether there is a valid acceptance between Aida and Laila, which constitutes to be a binding contract. The acceptance goes by the definition, where it is the exercise of the power by the person to whom the offer has been made, mainly the offeree, to enter the contract by exchanging in return. It requires the consent of both parties to enter the contract. Upon acceptance by the offeree, the offeror will be bound to the valid formation of the contract. This legal dispute of counteroffer can be firstly seen in the context of common law position Hyde and Wrench 1840. In this case, by proposing a different figure, the plaintiff had rejected the defendant's offer and now makes a new offer which amounts to be a counteroffer. This counteroffer had destroyed the original offer and cannot revive it back by tendering a subsequent acceptance. Similarly, the counteroffer can also be viewed through the interpretation made by Malaysian courts. According to Section 2B of the Contract Acts 1955, acceptance is complete when the person who received the offer agrees to the terms of the offer. However, acceptance is subjected to be absolute and unqualified according to Section 7A. This means that the acceptance must be clear and definite by accepting all the terms in the proposed offer and must not have any conditions attached to it. In the case of Malayan Flour Mills, Berhad, and Saw Eng Chee, the court will have to examine the circumstances to ensure a meeting of minds corresponding to acceptance. In order for a valid contract to be formed, it requires a definite promise to be bound to the terms mentioned, which must be confirmed through an external manifestation. Similarly, in the case of Kahwa Bank Limited and Nadinusa, Kahwa Bank sued Nadinusa Sdn Bhd for default on banking facilities. Through a series of letters, the bank solicitors made a formal offer to settle the debt for a specific amount on certain terms. On the other hand, the borrower solicitors replied in writing, seemingly agreeing to the settlement by including language that suggested they were adding a new condition or clarifying a point not in the original offer. The primary issue was whether the exchange of letters between the solicitors constituted a final and binding agreement or merely a qualified response that amounted to a counter-offer or ongoing negotiation. The Federal Court held that in the specific circumstances, there was no concluded contract for the second and third suits because there was insufficient acceptance of terms. The acceptance was deemed qualified, not absolute and unqualified as required. This shows that the acceptance must be clear without amending the terms of the offer. If an offer is accompanied by a counter-offer, then it is upon the original offeror to accept or reject the offer. Lastly, it can be seen in the case of Sriwijaya Sdn Bhd and Dato Haji Ahmad Tarmizi. In this case, David Wong, the Chief Justice of Sabah and Sarawak Court, held that the acceptance must be absolute where all the terms set out in the offer must be accepted and any conditional acceptance made by the offeree which amounts to the rejection of the proposal would not revive the original offer later. In conclusion, since Aida made a counter-offer to Laila's initial offer, this means the acceptance is not valid in the first instance. This is due to when the counter-offer has been made, the role of the offerer now has changed, where Aida is the new offeror, while Laila is in the place to either accept or reject the new offer. Later, when Aida had changed her mind to accept the original offer, the offer has already collapsed, which now cannot be revived as Aida has rejected it before. Thus, the absence of valid acceptance to fail a contract does not form a legal binding between Aida and Laila.
This is the end of our presentation. Thank you.